talking about? I did have that email with the 3 dockets. Yes. There, anywhere. This is not here.
All right, we're here for our miscellaneous dates. Let's get started with our list. Mr. Gilbert. Robinson.
Yes. GPS monitoring, okay. Morning, Your Honor. We're here with Donald Robinson and 24 CF 2138 on a motion to reinstate bond. Your Honor, we've had discussions with state, and state is willing to, I understand, state is willing to stipulate to reinstate the bond with the original conditions with the addition of a GPS monitoring device.
And what was the original condition?
I'm not sure. I don't believe there were any special
Stipulated
conditions.
to something we don't know what it is.
No, there wasn't any. There was no conditions.
Well, I would ask for pre-trial services, weekly check-in by phone and GPS monitor.
It's a trafficking charge, right?
Yes, drug trafficking, so there is no victim.
What was the cash or professional portion?
15,000 cash or professional. Originally it was 16.
And the bond was revoked because there was a new offense which he's pled to?
Yes.
He pled in, served his time for that.
I know it was talked about a little bit yesterday, but Mr. Gilbert, if you could explain on the record now as far as the issues with, briefly about the depositions that I think are kind of the issue that have been delayed for several months because of an officer not being available.
Yes, Your Honor. Well, and actually that has been resolved. We got dates yesterday, and so we're tentatively scheduled for October 3rd.
Okay.
We'll be putting out subpoenas on that. Did you want me to go through the history?
That's been the delay, right?
Yes, sir.
And I know that was part of somewhat of an argument that you made yesterday during our pretrial conference, was that due to, I guess, some family leave and some other things, that the officer who you needed to depose hasn't been available since you started back in February, trying to get that coordinated, which I think is part of the reason why you're asking for a reinstatement of bond, is because this case has been delayed due to no fault of really anybody that's involved, but certainly not the fault of the defendant, Mr. Robinson. Do I have that accurate?
Yes, Your Honor.
All right. Did he pay a cash bond, or was it a bondsman?
The bondsman?
Okay. Do you know if they're going to go back on the bond, Mr. Robinson? They are. Okay. Well, based on the state stipulation, I'll go ahead and restate it to the $15,000 cash or professional. It's going to be pretrial services, GPS monitor at $1 per day. Check in with pretrial services once per week by phone. Anything that I missed?
No, Your Honor.
Okay. If you could get me an order to that effect, the clerk's minutes is usually suffice, but
We'll do.
I always think it's better to have an order that has the judge's signature on it for purposes of the record. All right. And we're already set for 10. Well, let's move it to 10/27. If I expect he's going to make the bond now that y'all have agreed to it. All right. So it'll be October 27th at 9 o'clock for his pretrial. We set it for the 29th because he was incarcerated when we had it yesterday.
Give me the 27th. Yes, sir. Thank you, Your Honor.
All right, thank you. Jesperson?
Good morning, Your Honor.
Good morning, Mr. Stewart.
May it please the court, Brad Stewart, on behalf of Donald Wayne Jesperson, Judge. For the record, this is case numbers 25 CF 36, 24 CF 368, and then 23 CF 1009 and 1008, Judge. We are revisiting this matter at this time. I believe the court had indicated that you were going to reach out to Judge Drake in Santa Rosa County.
And I did, and we went back and forth on a couple of emails. He's already entered an order transporting, so once we finish up today, they're going to transport him as soon as for next week for court.
Outstanding, Judge.
And that's, again, I didn't try to step on what y'all were trying to do and the way you're trying to do it, but if we make that extra little email or phone call, it typically makes things go a lot easier and will probably save Mr. Jesperson a month or more of going back and forth between here and the Santa Rosa
Yes,
County
Your Honor.
Jail. So,
Thank you.
yeah, you're welcome.
And Judge, in accordance with that, I've also reached out to the state attorney's office over there. We've smoothed things out with regards to that negotiated agreement. That should be handled very swiftly there. So at this time, Mr. Jesperson is prepared to enter a plea to, as charged to case number 23 CF 1009, Judge. The agreement calls for an adjudication, 36 months in the Department of Corrections as a minimum mandatory with credit for all time served. Judge, that's approximately 558 days. Fine and court costs imposed as by law. I believe it's a $50,000 fine, Judge. I'm not exactly sure what the court costs are on that.
Well, it's got, how many, 3 or 4 different cases?
The other cases and all counts shall be dismissed in
Okay.
exchange for a plea to that. I'm not, again, exactly sure what the court costs are. The cost and fine sheet seems to indicate a range,
All right.
but if I may, Judge?
Yes, sir. Is there a score sheet?
Yes, Your Honor, I'm printing it out. Yes.
All right, so the plea form that we looked at yesterday talked about a 60-day sentencing date. Obviously, we don't need that at this point,
That's
right?
correct,
Do you
Judge.
mind if I just cross that off?
Yes, Your Honor.
Oh, so you're determining court costs based on that percentage issue? Is that what that is?
Judge, I just used the fee sheet on the back. I mean, it had a range from $28,000 to $520,000, so that was that was the best calculation I could make based on that. Judge, my client's comfortable with assessing, we do know that there's a $50,000 fine and court costs as applied by law. I would request that that be assessed as a civil judgment against him. He's going to be incarcerated, Judge, as the court knows from the sentence.
Mr. Jesperson, if you could raise your right hand to be sworn, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
On Jesperson, 4787.
All right, Mr. Jesperson, you're hearing a handful of cases, 25 CF 36, where you're charged with aggravated battery, 24 CF 368, fleeing and eluding, 23 CF 1009 is the trafficking charge, and 23 CF 1008, possession. Do you understand your current charges? All right, I've been given a plea and sentencing agreement between you and the state. It calls for you to enter a plea of no contest to the information as filed in 23 CF 1009, which is the trafficking and methamphetamine charge, 14 to 28 grams, which is a first-degree felony punishment by 30 years in state prison, as well as a $50,000 fine. Is that your understanding? All right. And in return for that, you would be given 36 months in the Department of Corrections as a minimum mandatory sentence, credit for all time served, the $50,000 fine and court costs as required by law, which we'll see if we can't figure out because of that surcharge. And then all of your other cases will be dismissed by the state in exchange for that plea. Is that your understanding?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Have you gone over this plea and sentencing agreement with your lawyer?
Sir.
Did you understand and sign it? And are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently are you currently suffering from any mental health issues?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? Do You understand that by entering the plea, there won't be a trial of any kind. And you understand you're waiving your trial rights, which are listed on page 2 of that agreement that you signed. And you understand you're waiving all potential defenses that you may have.
Yes, sir.
All right, now that's listed as what your approximate time served is, but that will be determined by the jail and DOC. Do you understand that? So I'm not promising you that it's 580 or 558, but if your attorney's calculated that, you know, that's, I'm not sure about it because I don't have that ability to do that on the fly. All right, and do you also understand that this will be an adjudication of guilt, so it's a felony conviction? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, and what is your plea in 23 CF 1009, trafficking in methamphetamine, a first-degree felony?
Contest.
I'm going to accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement in the other cases.
Yes, Your Honor, in exchange for a plea to the trafficking case, the state dismisses the other cases that
All
are
right, state's
currently
dismissing
pending.
25 CF 36, 24 CF 368, 23 CF 1008. Is that correct?
Yes, Your Honor.
All right, in the 1009, it's going to be an adjudication of guilt, 36 months in the Department of Corrections is a minimum mandatory sentence with credit for all time served. It's going to be a fine of $50,000 and court costs. All right, in order to kind of get you moving, Mr. Jesperson, what court costs is required by law. Once they come up with a number, we'll tell you before you leave the room. But otherwise, you have 30 days to appeal the judgment and sentence. Did I get the score sheet? You got it. Any objections to that score sheet as amended, I'm sure?
No, Your Honor, we did amend it.
This is actually a downward departure as well?
I'm sorry, Your
It's a
Honor?
downward departure as well?
It is, based on a non-coerced negotiated plea.
Okay. You understand what that means, Mr. Jesperson, is that you scored 46.65 months, which is just under a year more than you're receiving because you made this plea bargain with the state. Do you understand that? And I'll just need you to step up to be fingerprinted, Mr. Jesperson. I know the order from Santa Rosa County has already been filed, from what I was told last night. So they should be coming to get you, hopefully, early next week to bring you over there to, I think you're going to have a court date on Thursday, but you might want to check on that, Mr. Stewart.
Yes, Your Honor. And Judge, I don't know if the court announced, but can we assess fine and cost as a...
It'll be a judgment. I'm sorry, you said that and I hadn't repeated it, so.
Very good.
They're saying it's just $515 in court costs, but it's all a judgment.
Judge, I do have one other matter. Mr. Eugene Carter, he was going to appear via Zoom from the Walton County Jail. We can certainly pass him until we get that set up.
Let me just see if he's there. He's there.
You are in the meeting now.
And Judge, I just need to ask Mr. Carter what his EOS date is, and if we can, and then formally set a hearing for that. Yep.
All right, Mr. Carter. This is Mr. Crater for the second time. Can I get y'all to turn the camera on over there in Walton? Can the Walton jail hear us? All right, Mr. Carter, are you there? Ooh, I think I just may have dropped out. Mr. Carter, are you there?
Yes, I can hear you.
All right, I can hear you now. Can you turn on that video or no?
I can call the officer, talk with him, mess with it.
Okay.
He called.
Yeah, I'm going to need you to do that. So if you, I'm going to pass your case while you guys work on that, and Mr. Stewart, I'll call you right back up as soon as we get it working, but I've obviously got to see him.
Yes, Your Honor.
All right,
One second.
all right. All right, Mr. Flowers, you want to take your case while we're waiting?
Thank you, Judge. Dakota Coffey. Mr. Coffey is,
I'll mute him for now. Go ahead, Mr. Flowers.
Judge, if I'm not mistaken, Mr. Coffey is here for sentencing. We appeared before this court on a violation of probation matter. Have discussed the matter with the state. We're ready to proceed. Judge, I do have something. The state has copies of this. May I approach?
Sure.
Judge, we've actually, in discussing the matter with the state, reached an agreement if the court would be amenable to our agreement.
Well, I looked back at it. I didn't see that he actually pled
I
last
thought that
time.
he did, but having said that, we're prepared to move forward.
I listed
with
as,
an
it's
admission.
listed as sentencing, but I don't think a plea was actually entered.
And that might be my confusion. I had it listed as sentencing also, Judge.
No worries.
That being the case, Mr. Coffey's intention all along was to admit that he violated the terms of his probation, understanding that he's waiving his right to an evidentiary hearing before this court, the standard of proof being beyond or by preponderance of the evidence. That's what we had discussed. I thought we had entered that plea, but Mr. Coffey, that's what we had discussed. Is that right?
Yes, sir.
And we both anticipated, and I think the state and myself may have made the same assumption that had occurred.
I went back and watched it, and I didn't see where we actually entered the plea. Then maybe I missed it, because I know we've had quite a few court dates.
But we're prepared to do that and to have the matter resolved today, having spoken with the state attorney, and she and I have reached an agreement as to a recommended sentence. I think
What
that's
is-
accurate.
And what is
I don't mean to speak for you, but doesn't that sound accurate?
What would be the sentence we agreed upon?
What we ultimately agreed upon was 11 months, 29 days in the Okaloosa County Jail with credit
Yes.
for time served.
Yes.
We have
Revoke and
discussed
terminate
many
the
options. As the court is aware, I've attempted many options, as has the state. Respectful negotiations have reached that point, and Mr. Coffey understands that, and we're prepared to move forward in that fashion.
Okay.
I think that would be fair to say.
Yes, yes, thank you.
11 months, 29 days concurrent between the two different cases, revoke and terminate?
Yes, sir.
Okay. All right, Mr. Coffey, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. You understand that you're here on two violations of probation. That's 23 CF 2767 and 23 CF 2768.
Yes, Your Honor.
All right. And have you discussed it thoroughly with your attorney, Mr. Flowers?
Yes.
Are you satisfied with his representation?
Yes, Your Honor.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you admit your violation of probation today, that there won't be a hearing where the state would have to prove by a preponderance of the evidence that you violated your probation?
Yes, sir.
And you understand that you're waiving all potential defenses you may have to that violation of probation?
Yes, sir.
And is your understanding the terms of the plea is going to be 11 months, 29 days in the Okaloosa County Jail, revoke and terminate your probation, and be a $100 VOP fee?
Sorry, I didn't mean to interrupt.
No, that's fine. Go ahead. Is there anything you need to discuss with your lawyer
Judge,
first?
he has a question about something that we can deal with immediately after your announcement, if that's okay with you.
I've got,
My
I just want
apologies.
to,
My apologies.
that's fine. I just want to make sure that if it's about the plea, that we discuss it, but you're saying it's not.
It is not.
Okay. Obviously, he'll be given credit for time served. Is that right?
That's correct.
Was that the question?
It was not. That's what we get a lot, Your Honor.
Yeah, I know. I just wanted to make sure, 'cause that's
Yes, sir.
usually until I say it, that's what the big concern is. All right. And do you understand, was he adjudicated on the underlying?
He was
Yes.
on the underlying offense, and
All right, so be adjudicated guilty on the other underlying that will remain in place. And do you understand, Mr. Coffey, that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
Okay.
Yes, Your Honor.
And what is your plea to the violations of probation in 23 CF 2767 and 2768? Are you admitting or denying that?
I admit.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to sentence you to 11 months, 29 days in Okaloosa County Jail, revoke and terminate your probation, $100 VOP fee, and then if there's any outstanding monetary, do you want judgment or time to pay that?
Judgment, Your Honor.
All right, any non-monetary, or any monetary outstanding conditions will be sent to judgment. Anything that I've missed?
No, Your Honor.
Okay. All right. Mr. Coffey, I just need you to be, no, we don't need him fingerprinting. 'Cause
You
he
already
was
have
already
his
adjudicated, and you've got 30 days to appeal the judgment and sentence, Mr. Coffey.
I'll talk to her about all that, okay?
Your Honor, did I tender the score sheet last time? If not, I have.
I don't think so.
I got it here.
Judge, that's all I have. Thank you,
Mr.
sir.
Have a good day. Oh, score sheet, any objections to
No
that?
objection to
Mr.
the score sheet. I'm aware of the point total, and then there's no objection to that, Judge.
All right. Yes. Just to make sure it's clear, there's no objection to the score sheet, which was 27 points, which means that this is a guideline sentence.
Thank
All
you,
right,
Judge.
thank you, Mr.
Thank you, Your
Brown.
Honor.
Have a good day. All right, Mr. Stewart, you want to take Mr. Carter now that he's up?
Brad Stewart on behalf of Eugene Carter. Mr. Carter, can you hear me?
Yes, sir, I can hear you.
Okay, Mr. Carter, can you refresh our recollection with regards to your EOS date and time? Because we are going to have to transport you over here in order to perfect a plea.
Is that for 10?
Can you tell us that again, Mr. Carter? We lost you.
Can you repeat that, please?
September 10th?
September 10th. All right, you just want to set it for a date after that?
Judge, I would like to set it for a day before that because the resolution here is supervision, and so he would be released at or around that time if we can, if the court has a date that we can do, and I'll submit an order for that, to that effect for
Have him
transport.
transported? Is Walton County going to let that happen?
Do what?
Is Walton County going to do that before he finishes his sentence?
Well, Judge, I think the court would have Okaloosa transport him, right?
Well, I understand, but are they going to release him for that purpose?
When we entered the plea, I made the court aware it was part of the plea that he may receive day-for-day credit if he's transported to this jurisdiction.
Just want to make sure because
Yes, sir.
As we've found over the past couple of months, DOC and some county jails seem to think orders transporting are just suggestions.
Understood. Obviously, I can't speak for Walton County.
I haven't had the problem with Walton County,
So,
but I just want to make sure, because we've had several cases where they've either forgot to do it, or they say they didn't get the order, or they get the order and say, well, we forgot to bring them over. So I just
sir.
want to make sure that's going to happen. So the best I can do is give you September 4th, which is next week, Thursday. If you can get them over that quick. And why don't we do that for the afternoon at 2 o'clock?
yes, Your Honor. I'll file a notice in that regard and provide an order. Judge, order is sufficient. Do I need a motion for the court?
For transport?
Yes.
No.
Very good.
But make sure you get it over to me, send it directly to Ms. Guzman, and I'll get it signed as soon as I can, but you know where I'm going to be all day.
Yes, Your Honor, of course. Yeah. Mr. Carter, did you have a question?
Oh, yeah, I was going to ask, so I'm going to be transported to Okaloosa and finish out right here on my spare.
Mr. Carter, I'll handle those questions. If you would, I've tried to schedule several video conferences with you. If you'll have a look at your tablet, and I'll take care of those questions. We'll try to set something up today, okay? Okay, I'll see you soon. Your Honor, that's all I have. May I be excused?
Yes.
Thank you, Your Honor.
Thank you, Mr. Carter. All right, Mr. Cotton.
Morning, Your Honor. I'll date it. Just to make sure it's the original plea and the subsequent modifications. Right. In other words, whatever. Your Honor, may I approach?
Yes.
Thank you.
Yep.
It's your birthday? All right, let's see here.
Judge, and on that agreement, I did not check the box, but it is under the count if you want to check adjudicated on that, just to be clear.
Put a blue check mark there.
Blue
for you.
check mark.
All right, do we know how much time he's served in Covington County in the residential treatment? Because if he's getting credit for it, someone's going to have to tell us what it is, because the jail can't really figure that out for us.
I think the jail already has it, Judge,
Okay.
and the reason why is this. To be clear, he did 6 months on the nose
No, sir, it was,
in rehab.
no, sir, it was, like 5 months and 2 weeks.
5 months to, I think the jail has it because he has been serving. The deal was, once he got out of rehab and all that, he's been doing it on weekends.
I seem to remember that, but
And so essentially, when he got violated, obviously, where they're just there and it's just running, and so he's just going to complete it out. So my understanding from my client is they have already calculated that, and that information's been provided to the jail from probation. I did tell him, for whatever reason, he needs to do a credit check when he gets back, and if I need to help get that information over there again.
check.
Yeah, you know, a little different. So that I could assist if that was necessary. I mean, he can tell you what he did, but
Typically, the jail files something in the court file with that shortly after sentencing, I believe. But then again, you may not see it if it gets filed.
yeah, and I will double check that. But just so long as we're clear, he's getting that credit. It was given to him in the original plea agreement, Judge.
Okay.
So that's just repeated in here to make sure.
Just follow up on it if it becomes an issue, and we can certainly address it.
I'll handle that.
All right. Mr. Smith, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, Mr. Smith, you're here in 24 CF 258 with a violation of probation where your maximum exposure was 5 years in state prison. I've been handed a plea and sentencing agreement that calls for you to admit your violation of probation, be adjudicated guilty. We would modify your probation to reinstate your probation, add the additional condition that you shall complete a substance abuse evaluation within 60 days of release from the Okaloosa County Jail and any recommended treatment. Also complete the remaining 11 months, 29 days of your sentence, whatever that, minus your credit, that remains as straight jail going forward. Is that your understanding?
Yes, sir.
All right, and you also, as stated by your attorney, all time served in the residential treatment program that's already been completed and time served in Covington County while you were awaiting this, I believe. And that's Alabama case DC 23243 and TR 23373 would be credited to you, Mr. Smith, as is agreed upon by you and the state. And then you'd have to complete all original terms and conditions of the plea and any subsequent modifications that shall be reimposed. Probation have any questions about this? I just want to make sure, because the 1129 was already part of the probation, but he was serving it on weekends.
He was serving it on weekends, but I think he had already started his supervision.
Yes, But so it said he's going to finish out all the jail time now, and when he gets out, he'll be back on his regular probation.
To complete whatever remaining term of probation is there.
All right, that's
Yes,
why I always ask, just to make sure
Sure,
everyone's on the same
absolutely.
page. Is that your understanding of the agreement, Mr. Smith?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
Do you have a score sheet, Mr. Sheik?
I can print one out quickly.
Thank you. All right, Mr. Smith, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, Your Honor.
All right, are you satisfied with your attorney's advice and representation?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? And do you understand that by entering an admission to your violation of probation, you're giving up your right to a hearing where the state would have to prove that you violated your probation in the ways they've alleged? And do you understand you're waiving any potential defenses to that violation of probation?
Yes, Your Honor.
And you understand that you'll be adjudicated guilty, and if you're not a U.S. citizen, you could be deported because of this. All right. And what is your plea to the violation of probation? Are you admitting or denying?
No contest?
Yeah, admit.
You're admitting. Okay. All right. You're admitting your violation of probation. The court's going to accept your admission as freely, voluntarily, knowingly given. Again, adjudicate you guilty, modify your original probation to reinstate it, and add the additional condition that you shall complete a substance abuse evaluation within 60 days of your release from the Okaloosa County Jail and complete any recommended treatment. Just point out, 60 days sounds like a lot, but you might not get an evaluation very quickly, so make sure to do that as soon as you can once you're out. Otherwise, they may give you a date that's past 60 if you wait too long.
Yes, Your Honor.
All right. Also, you're going to complete your remaining part of your jail sentence. You get straight jail starting today. That was 11 months and 29 days, minus obviously the credit you have in the jail now, your residential treatment that was previously credited, as well as your Alabama time, which was previously credited. If there's any issues with that, your attorney will bring that back to our attention, and we'll potentially have another hearing to work that out. All original terms and conditions of the original plea agreement, you have to complete those, and any other modifications that may be reimposed. $100 VOP fee as well. And I believe I have everything other than the score sheet. Is it a guideline sentence, Mr. Sheik?
I believe it's a downward departure with 1129, Your Honor.
It is, Judge, but we did it as a modification, so I don't think that's necessary.
Okay.
How the court wants to handle it.
You're
May I
right.
approach?
Yes, sir. Since it's a modification.
Yes.
All right. All right, so Mr. Smith, although you've got a little more time to serve in the jail, I need you to meet with probation right now. They'll talk to you for a minute, then you'll come up. We don't need your fingerprints because we already have those, correct? And then you'll have 30 days to appeal the judgment and sentence of the court.
Good.
All right.
Call me if you got questions. Check your jail credit today and get with me. If there's a problem, let me know. So you got a copy. All right, Your Honor, that's all I have before the court. It's good to see you.
All right, you too. Have a good day.
Thank you, Judge.
Ms. Dudley, are you ready?
Your Honor, this is Antrion Coleman in 17 CF 1004. We have entered a denial on this VOP. We asked for a continuance. We're waiting on some information from the state to see if there's going to be an offer and what the offer is going to be. There's some information that we need to get before we can even get to that point.
Okay. Who's the state on this one? Ms. Barrickman or Ms. Basso,
Barrickman.
maybe? All right, what date do y'all want to put it on?
I guess the next available miscellaneous, and we'll see where we are.
September 25th at 9 o'clock? Without subpoenas?
Yes, sir.
All right, Mr. Coleman, we'll see you back on September 25th at 9 o'clock. If y'all work out whatever needs to be worked out and you want to bring it in earlier, you certainly can.
Yes, sir.
All right. Thank you, Mr. Coleman.
Yes, sir. Yep, I will. Okay. Your Honor, next I have Dakota Josie.
Oh, okay, let's change it. Yep.
Your Honor, this is Dakota Josie in 23 CF 1095 and 23 CF 1330. Your Honor, if I may approach, I have a plea agreement and a score sheet.
All right.
And I did correct the score sheet based on the fact he was on for a misdemeanor on the second case and not a felony.
Okay. Regardless, you didn't score, correct?
Yes, he does not score, Your Honor.
All right, Mr. Josie, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Dakota Josie, March 30th, 1994.
And Mr. Josie, you're here on violations of probation in 23 CF 1095 and 23 CF 1330. Do you understand that?
Yes, sir.
All right, I've been given a plea and sentencing agreement that calls for you to admit to your violations of probation, be an adjudication of guilt, time served, revoke and terminate your probation, $100 VOP fee that you can pay within 60 days.
Yes, sir.
Is that the state's agreement? Yes, Your Honor. All right, and it's a guideline sentence based on the fact that he only scored 38.3. Sorry, I missed the VOP points on the second page. All right, Mr. Josie, is that what you want to do today?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
All right, are you satisfied with your attorney's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to take this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea, there won't be a VOP hearing where the state would have to prove that you violated your probation?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
You understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the two violations of probation? Are you admitting or denying those?
Admitting.
All right. I'm accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty on both violations of probation, time served, revoke and terminate your probation, $100 VOP fee, which must be paid within 60 days.
Yes, sir.
All right. Any questions or anything I missed? All right. You have 30 days to appeal the judgment and sentence of the court, Mr. Josie.
Yes, sir. Thank you.
Thank you. Have a good day.
Your Honor, I believe that's all I have.
Are you Vicky Lively?
Yes, sir.
Okay, let me just pull up your case. All right, Ms. Lively, you're here in 2019 CF 990 for a violation of probation. You're currently not represented. Do you plan to hire a lawyer, or do you want to ask for a public defender?
I'd like to have a public defender, please.
Okay.
I
How long have you been in the jail?
I've been here 55 days,
Okay.
and I don't have anyone to help me.
I've got you. So what I'm going to have to ultimately have you do is fill out an application for that, but I'm going to go ahead and appoint the public defender based on the fact that you've been incarcerated for the past 2 months. This is Mr. Maddox from the Public Defender's Office. This is a violation of probation based on a new law violation.
Your Honor, may I speak?
Why don't you talk to Mr. Maddox really quickly first, just to make sure you don't say anything that could be detrimental to your case.
They have an offer in the case?
Just
The
for
new law
your
violation.
understanding, Mr. Maddox, the new
Yes, Your Honor.
case is 25 CF 1351, 2 counts of possession of a controlled substance without a prescription. It's currently set for pretrial conference on October 29th.
Yes, Your Honor. Okay.
Yeah, the offer, and correct me if I'm wrong, this was the recommendation from probation for the probation was to be placed on regular probation and ordered to do drug evaluation completed in 60 days and treatment within, or 30 days and treatment within 60. I believe that was the offer or the suggestion from probation for the new one, or for the violation of probation. For the new law violation, it would be an adjudication of guilt, 2 years probation, and have the same requirements on it. Wait. I'm sorry, I hold off on that last one. I was reading my notes incorrectly on the new law, of the new case. Yes, we may have to, the lowest permissible sentence right there on that one is 29 months, so I need to review it. So, I'm not saying that that's what the offer is gonna be, I just want.
Based on that, Your Honor, we're here on the VOP itself today, correct? We didn't enter a denial, Your Honor.
Mr. Maddox, you wanted to just run along with the new law violation?
That would be fine, Your Honor.
And if you want to bring her back by the end, we might be able to come up with something.
All right, Ms. Lively, a denial's been entered. I'm going to put this case along with your other case on October 29th. I'm sure the state and Mr. Maddox are going to discuss your case more thoroughly once they've taken a look at it. If there is an agreement, you can certainly put it on an earlier court date if you need to.
Certainly, Your Honor. Thank you.
All right. Thank you, Ms. Lively. Caleb Humbert with no attorney.
Landon, Your Honor, if I may?
Yes.
I'm just conferring with the other ASA. I think we may be able to come to agreement. Can we push her off until, pass her to later today, Your Honor?
Ms. Lively, they're going to come back and talk to you. They're going to keep you here, and maybe they can work it out today. All right. Thank you. All right, good morning. You're Mr. Humbert, correct?
Yes, sir.
All right, welcome back. I know you were here just a few weeks ago or something like that for an early termination, but for some reason it wasn't on our docket. Ms. Leone, I think we talked about this a few weeks ago, and we pushed it off so y'all could take a look at it. It's an early termination request.
Yes, Your Honor. There were 2 victims in the case who were contacted by my office.
Okay.
One of them objects to the termination. The other one didn't object. The state's position is that due to the charges, I'm not going to agree to early termination.
Just a second. I just have to pull it up in the clerk system because it's not showing up in mine. I reviewed it again yesterday, but I just want to make sure I've got everything open. Probation have any opinion on early termination from Mr. Humbert?
Is a violent felony offender of special concern, so probation would not recommend early termination. However, he has completed all conditions.
Mr. Humbert, my concern is the allegations that were in the initial reports and that you entered a plea to involved what appears to be two different road rage incidents where you fired a firearm at other people. I understand you didn't score under the guidelines, which also surprises me. But 3 years of probation for putting not only the victims' lives in jeopardy, but anyone else who happened to be nearby. That this was two different situations that happened, according to the report, 5 days apart. It's indicates that this is not just kind of an isolated incident, and that twice in a week, you may have done something that would have put you in prison for the rest of your life. So I think 3 years probation is more than fair. So I'm going to deny your motion for early termination. All right.
Sir.
Thank you, Mr. Humbert.
Thank you.
Morning, Your Honor.
Morning.
Please, the court. Before us is Bobby Wilson, Dixie Dan Powell on behalf of Mr. Wilson. I met with Mr. Wilson several times. And went over the plea and agreement with him. May we approach, Your Honor?
Yes. Thank you. Anything, Ms. Basso, before I get started?
No, Your Honor. This was a de minimis violation, but it was in fact a violation, so we do want to hold Mr. Wilson accountable, and this is the state's agreement.
All right.
I will have to give you a score sheet today.
Yes. I'm assuming it's going to be a departure.
It is, Your Honor.
Yes, Your Honor.
And that departure is based on uncoerced plea bargain?
That is correct, Your Honor.
All right, Mr. Wilson, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth?
Bobby Jelks Wilson, Jr., January 24th, 1957.
And Mr. Wilson, you're here on a violation of probation in 18 CF 2207. Where the agreement that I've been handed calls for you to do 6 months in county jail, credit for time served, be released back and reinstated to that initial probation to complete all those same terms and conditions, and then a $100 VOP fee and a $100 cost of prosecution, and that you're waiving any prior DOC credit. Is that right?
Yes, sir.
All right, so your credit only goes back to your arrest back in April.
Yes, sir.
Is that your understanding of it?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir, I just did.
Okay, and are you satisfied with your attorney's advice and representation?
Yes, sir, I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering an admission to your violation of probation that you are giving up any potential defenses that you may have to it?
Yes, sir.
And you understand there's not going to be a VOP hearing where the state would have to prove that you violated your probation.
Yes, sir, I understand.
And what is your plea to the violation of probation? Are you admitting or denying it?
Yes, sir.
Admitting or denying?
Admitted.
Okay. I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to, obviously you've been adjudicated guilty previously. I'm going to sentence you to 6 months in the county jail with credit going back only to April 14th of this year. You'd be waiving any potential DOC credit that you had. Once you've been released, you're going to be reinstated to probation on the same terms and conditions of your original probation, $100 VOP fee, and $100 cost of prosecution. Probation have a question or a concern? GPS as required pursuant to his probation will be required before release. Yes. All right, you understand that they'll have to have that
Yes, sir.
GPS monitor before you leave the jail. I've read what it is, that the state says it's a de minimis violation, but this happened within virtually days of your release from prison, so I want to make sure you understand how seriously this is going to be taken.
Yes, sir.
If you have any other further violations, even if they're de minimis, do you understand what that means? Even minor violations are going to be considered serious.
Yes, sir.
All right. All right, Mr. Wilson, we already have your fingerprints. I'll need you to talk to probation before you leave, and you'll have 30 days to appeal the judgment and sentence. Again, this was a downward departure based on uncoerced plea bargain, and as the state announced it as a de minimis violation. Thank you.
Your Honor, for the court's reference, we filed a letter from the pastor and the grandmother of the young boy that he shook his hands with, but.
Well, I understand. That's the de minimis violation.
Yes, sir.
No contact with minors mean no contact with minors.
He understands also.
I understand,
Yeah.
but then that's why it's 6 months and not another DOC sentence.
Yes, sir. Thank you, Your Honor.
Get the court score sheet, Your Honor.
Thank you, Ms. Boston.
Know when you're going to get out.
Mr. Klein, did you say?
That's all I have.
Oh, there he is. Thank you, Mr. Powell.
Your Honor, this is Mr. Ricardo O'Brien approaching the podium. He is present in 18 CF 1425. This was a remand from the First District for resentencing. The situation with Mr. Bryan is he just got to the county jail yesterday after I had already
I
left
looked it up
Westfield.
yesterday and saw his date was yesterday.
Right, so I was already on the south end by the time he got booked. I did talk with Mr. Bryan this morning. I am going to ask the court to continue this to the court's miscellaneous date in September, the later date in September. I would also ask the court to order that Mr. Bryan remain in the Okaloosa County Jail pending that court appearance.
I'm fine to do that, Mr. Kleins, but if you could send me an order that says
Absolutely.
that to make sure it's not just in the minutes.
Yes, sir. I will do that.
I know you've only got a chance to talk to him this morning, but my understanding the remand was to have another hearing on the motion for new trial.
That's correct.
As well as the sentencing.
That is correct. And one of the things I need to talk to Mr. Bryan about is whether he wants to proceed pro se, which he did most of the time, or if he wants me to proceed on his behalf. So there might even be a Feretta hearing thrown in. So,
Okay.
But those are I agree with the court. That is what the DCA said. The motion for the new trial and the sentencing have to be redone.
My understanding is the judge at the time had not asked him right before the motion for rehearing or for new trial, and then asked him minutes later.
Yes.
But then that's why it's come back. So,
Yes.
which I'm not making any commentary other than, sometimes that happens.
I know. We all know how things proceed sometimes.
All
in
right,
court,
so Mr. Bryan, we'll bring you back next month, so Mr. Kleins has a chance to talk to you about it. If you still wanted to proceed pro se, just make sure you tell him. He'll probably discuss that with you. If that's what you're going to do, I'm going to talk to you about that through what's called a Feretta inquiry, as you know, because that's part of the reason why the case is back from the District Court of Appeal. And then we'll discuss whether or not there's going to be a further hearing on the motion for new trial and a new sentencing hearing, because I think there was issues with the sentencing as well, right? All right. Let's put it on September 25th at 2 o'clock. And Mr. Kleins, if you have an idea on what that motion's going to be, or that hearing's going to be or not be, just
Certainly.
give us a heads up so we can all be properly prepared.
Yes, sir.
All right.
All right, I'll come talk to you, okay?
Thank you, Mr. Bryan.
This is Shane Fell. Pretty much a similar situation with Mr. Bryan. Since Mr. Fell's last court appearance, he was taken back to the department. He didn't get back to county jail until yesterday. In the meantime, Mr. Fell wrote me a letter chock full of authority. Unfortunately, when it got scanned into our computer program, it's very faint. And so, I was trying to read the numbers on the citations. So I need to ask to continue Mr. Fell's case to the September 25th docket so I can go to the jail. As a matter of fact, I don't know if the court's aware, but the motion that Mr. Fell filed is not currently in the clerk's website. I looked 2 days ago, and it was not in either of the potential cases that we're talking about here. So I did talk with Ms. Barrickman. She's going to send me the motion. I've gleaned what I think the argument is based on some letters that he's written to his previous attorney. So, but I need him to stay in the county jail so I can go up and go over the authorities he's given me and what exactly his motion's arguing. I will say that Mr. Fell does want to go back to the department. I've told him I can't have him going back to the department until this is resolved because I can't do this long distance. So although the court's most likely going to be putting this on the September 25th docket, if we can advance it on a Thursday pretrial detention docket between now and then, I would like to do that if the state can make that happen, because Mr. Fell is in a program in the department right now, and so I want to get him back as quick as I can, but I just need him to be here until we get this hearing taking place.
Eric, man, what's the state's position?
Yes. I'll tell you what you.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers, and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m.
All right. So, Mr. Fell, what we were just wanting to discuss is just this particular issue. I've informed both your lawyer and the state that I've dealt with this issue relatively recently. It's not exactly the same, but the cases are the same. And so Mr. Kleins is going to talk to you. He wants to read your actual motion because for some reason it's not appearing where he can see it. And then he'll talk to you about if it needs to be amended or modified in any way. But we're going to try to speed this through as best we can while also being efficient and getting it right.
Yes, sir.
All right. So we're going to put you on the September 25th date at 2 o'clock. But there's a chance we may have it resolved or a situation where I can just make the decision based on reading everything, which up to this point I've read everything there is, but there could be more. All right. Thank you, Mr. Fell. Okay. All right. Mr. Nielsen, can somebody flag him? Next one is a juvenile. If we could turn off the camera, please.
And she was supposed to get me a report by yesterday. I didn't get it by yesterday, so I called her back. She advised me over the phone that Mr. Stewart has been found competent to proceed. So they will be providing the court with an order updating the court on the competency status. I think the reason why she told me on Tuesday that she would send me some kind of a PDF by Wednesday, I don't think she was aware that he was going to be found competent, but I think she talked to the staff and was told, no, he's competent to proceed. So the court should, I think the court should go ahead and continue this to September 25th, knowing, and I'll stay on top of this, knowing that there's going to be a report coming through from Florida State Hospital.
Did y'all not get it this morning?
No, I have not received it.
All right, I received emails. Let's see. All right, there was an e-filing this morning at 8:12 Eastern. That went to my assistant, but it looks like it went to Scott Klein's at rc1.myflorida.com.
To be candid, I haven't looked at my email.
I'm just
Yes, sir.
So just double check that you've received it, but it includes that report.
Perfect.
And so I received it at about 7:30 this morning. But obviously we'll need him here for that.
Correct. So if the court wants to kind of quick start the process, I can provide the court an order to transport.
Yes.
And, okay.
We'll put him for that September 25th date.
Yes, sir.
Let's put him for 9 o'clock. I think the afternoon's got a couple of bigger hearings at this point.
We'll go ahead and 4 orders coming your way, so.
We've got some work to do today, Mr.
And if I may approach, Your Honor, I have another order on Mr. Hernandez that we talked about yesterday. We did confirm that he does have a violation warrant. So this was the individual who has a violation out of Escambia County, and we were trying to confirm with the jail whether or not there was a hold on him. There is a hold on him, Lieutenant Cantler.
We confirmed there was a warrant. We just didn't know if it was holding him here or not.
Correct. So orally, I will ask the court to reduce his cash or professional bonds to signature bonds. Mr. Sheik does not have any objection. If I may approach with an
Just
order.
so he can basically leave Okaloosa to go to
Correct.
Escambia County Jail.
And actually, Lieutenant Cantler specifically said if he bonds out, we will serve the warrant on him, and he's going to go to Escambia. So, may I approach?
Yes. This is from yesterday. It's Giovanni. Yeah, Giovanni Hernandez, 25 CF 584. I'm just going to be signing this. So.
And Madam Clerk, he is currently on Tuesday's docket, but the intent, obviously, he's not going to be here on Tuesday. So if we can just ask to continue this to the October 29th date while we take depositions.
Anything else, Mr. Klein?
My 12:30 detention client is here. I need to go talk to him, and I'm going to email my assistant to get the orders headed your way. So once I get that email sent, I'm going to go talk to Mr. Presley. I'll pass it to the public defender, and then I'll be back in court.
Yeah, if y'all give me a heads up on which ones we're going forward on.
I'll turn that over to the state.
Okay.
Your Honor, Mr. Presley, I'm the one handling that. We've already discussed it's not going to be a pre-trial bond. I believe client seats agreed upon or
Okay.
Yes.
Your Honor, the one thing with Mr. Mims is you said that he might not be present because he had another court date somewhere else.
He was on 2 dockets for this and Judge Stone.
And
He was on the jail list for this courtroom. Imagine he'll be here.
Okay.
Does he have a pretrial detention hearing there?
Yes, he was on the list.
No, but for Judge Stone.
No, he was listed as having a pretrial detention with Your Honor, which was strange, and I was.
When I pull up the case, which is 25 CF 1600, it says it's assigned to Judge Stone.
Correct, Your Honor.
But it's not supposed to be?
I don't know what the situation is. I'm still looking at it as we
All right,
speak.
well, let's take a quick look at it. Location of the offense was Mary Esther, Florida.
I have let the South End attorneys know.
We expect to have him transported here? Well, I mean, because we were given an order that says it's supposed to be in front of me, but I don't think it's supposed to be. I'm not sure why it was. All right, let's see if we can't get that figured out in the meantime. 'Cause
I mean, because
I'm not trying to duck any hearings today, but I just want to make sure it's being determined by the assigned judge with the assigned lawyers.
understood, Your Honor.
All right. Mr. Powell.
Kim Parker, Judge, is a 2006 2020 CF and 2006 2025. This is a VOP. We've got a plea agreement worked out, Judge. Got to sign this one. Right here. Yeah. You get it?
They haven't transported our people for today yet, for pre-trial sessions. I just feel like the majority of every day is fixing issues that shouldn't have been a problem in the first place.
A lot of time, doesn't it?
I mean, it feels like half my day every day is that.
We approach
Come on up, Mr. Powell. Okay. Okay.
Your Honor, in Mr. Parker's case, he did have a prior DOC sentence, so he'll be waiving the prior credit from that.
So it's 90 days from the June date.
Yes, sir, from his arrest on the VOP is our agreement, and then reinstate to all original terms and conditions. With the one additional condition that's also listed on there. That is, Your Honor, that he would complete the risk assessment for any internet use within 90 days of being released.
That's correct,
A
Judge.
risk assessment within 90 days, okay.
90 days in jail from June the 4th. We didn't put any court costs, money, but I don't know whatever the minimum is, we can put down.
Cost of prosecution, to Madam Clerk.
$100 VOP fee and $100 cost of prosecution, right? So it's 100 and 100. It's just 100? Okay. One per case. So yes, 100 and 100. All right, Mr. Parker, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Kim Frederick Parker, 4 August 55.
All right, Mr. Parker, you're here on a violation of probation in both 2006 CF 2020 and 2025. I've been handed a plea and sentencing agreement that would have you admit to your violation of probation. You'd be reinstated to complete the original requirements, but the next 6 months are community control, correct?
No, we don't have that.
No, Your Honor, it was 6 months county jail.
Okay, so it's on one, but you cross it off of one of them, but the other one still has it.
Oh, okay.
So instead of 6 months community control, it's 90 days jail.
Sir.
Okay. All right. So again, the agreement, Mr. Parker, that you've gone over with your lawyer apparently is adjudication of guilt, reinstate to the original terms, 90 days in county jail going back to credit of June, is that June 4th?
Yes, sir.
From June the 4th.
June 4th of 2025. You'd be waiving any credit from DOC so that you can do the full 90 days here. And also you'd have to do a risk assessment within 90 days. Is there anything that,
Your Honor, I believe the risk assessment and all of that usually takes a little while because he has to go through multiple steps.
I think that was the intent. yes,
Okay.
sir. Don't
All
want
right.
it sitting out there.
So initiate the risk assessment within 90 days to get started through those several processes.
Understand that, yeah.
All right, Mr. Parker, did you understand the agreement? I know it was a little bit confusing as we went through it, because I want to make sure I'm
Yes.
accurate with it. All right, is that what you want to do today?
Yes, sir.
And my understanding, Ms. Basso, this would be technically a downward departure, although he's waiving his credit. It
It's
seems
odd,
like-
but yes, sir, it would be technically, I guess, by the score sheet, a downward departure, but
How much DOC did he serve?
I don't have that number. I can get it for the court if I need
DOT, prison? 13 years.
Okay, so he served 13 years, so technically, if he didn't waive this credit, this would not be a downward departure, right?
to. Correct.
Okay, that's what I'm trying to figure
Okay.
out, so.
Good thinking, Judge.
All right, so Mr. Parker, did you go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And are you currently suffering from any mental health issues or concerns?
No, sir.
And has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that by entering admission to your violation of probation, that there won't be a VOP hearing where the state would have to prove that you violated?
Yes, sir.
Issue with probation again, or no? GPS, okay. Thank you for reminding me on that. All right, and do you understand that you're waiving any potential defenses you may have in your case, Mr. Parker?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given in the violations of probation in 2006 CF 2020 and 2025. Reinstate you to complete your original terms of your probation, adjudicate you guilty, require that you start your risk assessment no less than 90 days from your release. Both of these cases will run concurrent. You'll get 90 days county jail with credit for time served going back to June 4th of 2025, but otherwise you're waiving your prior DOC credit. Again, if it would be a downward departure based on the 90 days versus what he scores, but since he's waiving all of his DOC credit, I don't really consider it a downward departure because he would have gotten all that, right? All right. All right, also a $100 VOP fee. Anything that I've missed?
No, sir.
All right, GPS device will have to be attached before you're released from the jail, Mr. Parker.
Yes, sir.
All right. You have 90 days to appeal, or 90 days, 30 days to appeal. There's a 90 and a 90 in there. I got 30 days to appeal, but I need you to go talk to probation before you leave the courtroom this morning.
Yes, sir.
Thank you.
That's all I have, Judge. Thanks a lot.
Oh, I'm sorry, two $100 VOP fees for a total of
Two $100.
$200.
Over here, Mr. Parker.
Getting my battle fatigue limit. All right, Mr. Kleins, did you have something else?
Yes, Your Honor, we're going to bring Mr. Presley out. And I'm just going to take some brief testimony. The state's going to be asking for a $500,000 bond. I just talked to Mr. Presley. He is destitute. So I'm going to take some brief testimony from him on his financial conditions and then just make a brief argument on what we're requesting and why.
All right, let me just make sure of a couple things. This would be Larry Presley, 25 CF 1586. That's set for a 12:30 pretrial detention hearing. And because it's not going to be a pretrial detention hearing because the state's not seeking that, we're looking to do a bond hearing.
That's correct, Your Honor.
That's correct, Your Honor.
All right, Ms. Basso, have you contacted any of the alleged victim or victim's family?
Myself, I have not. Our victim advocate, Alice Barber, did speak with the mother. She was in agreement with him having potentially a bond.
Wait, hold
with
on
the
a second.
conditions.
What? He's not available?
We can, Yes, I was going to say.
Let's call some other cases so he can be
Sure,
present for this. I
absolutely.
just wanted to make sure as far as if a victim or victim's family was expecting to be here at 12:30.
She indicated to Ms. Barber that she did not plan to be here. I believe she's actually out of town.
Okay, just wanted to make sure.
Yes, cool.
Before we went forward with it.
All right, we're back. That was quick. Thank you.
All right,
All right, well, I tried to get up there.
right. It's one of those weeks, huh?
All the weeks are one of those weeks, Mr. Collins.
Your Honor, this is Mr. Mr. Presley. I'm going to take some brief testimony from Mr. Presley, if the court could put him under oath.
All right, Mr. Presley, can you raise your right hand? As much as you can. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You don't fall down over.
You're good. I was about to say, okay. So, Mr. Presley, what's your financial situation look like? How much do you make a month?
1,017.
About how much?
1,017.
1,017? That's how much money you make a month?
That's what I get every month.
Okay. What's the source of that income?
I'm saying.
Are you on disability?
Oh, yeah,
Is this a
yeah,
job?
yeah. No, disability.
Okay. How long have you been receiving disability?
Since 79.
Since 1979?
Mhm.
Okay. Who do you live with?
Me and my girl.
Okay.
And, huh?
When you say your girl, is this an adult? Is this a...
It's adult, it's adult.
Okay. Does anybody else live in the house other than you and your significant other?
No, no.
That's a no?
No.
Okay. How much do you pay for rent?
6.
So out of the $1,000 you get for disability, 600 goes to rent?
6 go to rent.
Okay.
And then water bill, light bill. That's it.
Does your girlfriend make any money?
No.
Does she receive any disability, anything like that?
No, no, sir.
Are you the sole source of income in your household?
Mhm.
Is that a yes?
Yes, sir.
Okay. How long have you been in the area?
7 years.
All right. And you're originally from where?
Mississippi.
Why'd you move over here?
Want to move over here?
Yeah. Why'd you move over here?
I guess because I want to move to Mississippi.
Okay. Do you have any intention of going back to Mississippi?
No.
All right. Would your intention be to remain here in the area while this case proceeds?
Yeah, I ain't gonna go nowhere.
Would you have any objection to being placed on a GPS monitor?
I don't care. I don't know what it is, but I do.
I don't have any other questions, Your Honor.
I have no questions, Your Honor. Mr. Presley?
Anything else you want to present, Mr. Kleins?
Not in terms of evidence, Your Honor.
Argument is also for bond.
Your Honor, yes, Mr. Presley was arrested on a single count of sexual battery of a victim under 12. As the court is aware, that is a capital felony. Based on the serious nature of the charges, the state is asking for a minimum of $500,000 bond, cash or professional. We would require pretrial services, certainly no contact with the victim or the family, no contact with any minors would be our request, Your Honor. Additionally, we would ask for a GPS monitor that should be affixed prior to the release from the jail.
Your Honor, Mr. Presley has no objection to any of the special conditions that the state is asking for. Just based on his financial situation, he gets roughly $1,000 a month split between two people. 60% of that money goes straight to rent. He is as skirting that poverty line as you can get. I mean, he's on it, you know. I feel kind of silly asking for a signature bond, given the nature of the charge. I'm fully cognizant of the seriousness of the charge. But there is no way he's going to be able to make any cash bound here. And so we are asking the court to consider a $30,000 signature bond. He'll be on a monitor. I don't really know what else we can do. I did talk with Mr. Presley. He advised me he has no prior record. Clearly, it's really early in the situation, so I don't even know if Ms. Basso knows if he does or not.
Actually, he has a burglary back from 1993, I believe, and in illegal possession of a shopping cart.
Oh, can I speak to that?
I
don't think we're worried about it.
Oh, okay.
I don't think I'm going to put a whole lot into that.
Oh, okay.
I know it's an unusual request, and But it's just based strictly on the evidence that he's presented today on his financial situation. That's the reason why we're asking for the signature.
Anything else?
No, Your Honor.
No, Your Honor.
All right. So, Mr. Klein, I understand your argument based on financial ability. However, to give someone a signature bond on a capital offense, number one, I don't think I can even do it. Two, part of the problem with a signature bond in almost any case, let alone a case like this, is if he was to fail to appear for court,
No,
there's, Mr. Presley, if I could,
Okay.
then there's no one to go looking for him other than law enforcement. There's not a bondsman who's going to make sure that he appears, and it's basically a promise to pay us into the court system the money if he doesn't show up. So there's really no teeth to that type of signature bond on a case like this where, not only is it's a capital offense, which means it's a mandatory life in prison if you were to be convicted. And so, there's concerns that because of that, there's potential flight risk. He's not originally from here. He hasn't been here a whole lot of time, doesn't have much connection to this area. So I understand that, he can't make a $500,000 bond. But it sounds like virtually any cash or professional bond I give him is going to be, he's not going to be able to make that, which I understand the argument is, well, then you shouldn't give him one. But I've got to protect the community based on the level of charge, the allegations that are made in the report that I've read, as well as whether or not he's a flight risk. Those are the main determinations in a bond hearing.
I don't mean to interrupt, but I would ask the court to consider a $50,000 cash or professional bond. I don't think he's going to be able to post it, but it would be a cash or professional bond.
It's going to be a $250,000 cash or professional bond with pretrial services, reporting once per week by phone and once per month in person. No contact with the alleged victim or anyone in her immediate family. No contact with any minors. GPS monitor to be attached before he's to be released. If he makes the bond, that'll be at $1 per day. Anything I've missed?
All the state was requesting, Your Honor. Thank you.
All right, thank you.
And I'll get the court another order. So.
I'll do those orders.
Okay.
I do orders on the pretrial detentions.
Okay. Yes, Your Honor. All right. I'll come see you at the jail. Okay. All right. Your bond's $200.
Once per week by phone, once per week in person.
That's all I have this morning.
All right. I'll believe you this time, Mr. Clines. All right. You have someone lined up? Okay. Whose case is that? Mr. Maddox?
Yes, Your Honor. Your Honor, this is Mr. Shamar Anderson before the court in 22 CF 2184 and 23 CF 2417. Both are violations of probation, Your Honor. State has indicated that their offer is going to be incarceration. We haven't pinned down a number quite yet, so we would enter denial at this time, Your Honor.
All right, what would you like to set it for, Mr. Maddox?
We just do the next pretrial conference, Your Honor.
Well, I typically like to keep the VOPs on the miscellaneous VOP dates.
The 25th then, Your Honor.
There's not another charge, is there, pending?
No, Your Honor, I don't think so. Any?
And are we doing that with subpoenas or without?
Sorry, Your Honor?
With subpoenas or without subpoenas?
Oh, without subpoenas at this time, Your Honor.
All right, September 25th, 9 o'clock, without subpoenas.
All right. I'll come see you. September 25th. Good morning. Miss Baggett, right? Okay. All right, this is Miss Tara Baggett before the court in 25 CF 910. Mr. Sheik, were you able to look at jail offer or an offer currently?
The offer is community control.
Okay.
How much time would it?
How much community control?
It would, for the remainder of the probation, it would convert to community control.
Your Honor, if we could pass her, but I think we'll have a resolution in the case.
All right, let's keep Ms. Baggett so that we can bring her back up for a potential
I'll come talk to you
resolution.
about it. All right. Yeah, Mr. Banks.
You,
Your Honor, I want your denial at this time. If we could have the September 25th date without subpoenas.
Who is this?
This is Mr. Lynn Banks, Your Honor, 22 CF 2873.
You want the 25th
Yes, Your Honor.
without?
Without.
All right, we'll see you back, Mr. Banks, September 25th, 9 o'clock,
sir.
without subpoenas.
Thank you, Your Honor. Your Honor, I think we're going to have a resolution in this case. This is Mr. Timothy Kami, 24 CF 1657, Your Honor. It's a violation of probation. If we could pass him.
All right, Mr., is it Comey or Kami?
Tommy.
Kami,
Okay.
okay. That's what I thought. I just wanted to make sure. All right, we're going to pass you, Mr. Kami. They'll bring you back up. It sounds like we may have a resolution to discuss.
Thank you, Your Honor.
All right, thank you.
Said Mr. Guzman. Ms. Guzman and Miss Guzman already. It's up on my file there. Already down. Already down. Good morning, ma'am. This is Ms. Guzman Arredondo, Your Honor, 25 CF 1469, additionally 21 CF 1012, and 23 CF 173. We're dealing with VOPs and new law charges here, Your Honor. For the new law charges in 25 CF 1469, we'd enter a plea of not guilty at this time, ask for 15 days to file any pre-arraignment motions and trial by jury. For the other two cases, we'd enter denials, Your Honor.
Oh, so the new law violation is set for this afternoon?
I would assume that's the situation, Your Honor.
Yes, it's set for 1:30. All right, what would you like to put it on, Mr.?
If we could have since there's new law charges and a variety of issues that need to be dealt with in this case, Your Honor, I would ask this track the pretrial conference date.
All right, it's going to be October 29th at 9 a.m. for pretrial conference. The VOPs will run with the new law violation. Was an information filed on the new charge?
Yes, Your Honor, it's right here.
Can I make an offer? I want to make an offer.
No offer, Nat. It's going to be a jail offer, or jail or DOC. Not right now. But
Thanks for your patience, Your Honor. I think that's all I have for this morning, Your Honor. I'll work on getting the other two pleas written up.
Actually, Nolan, I think it it was a
Ashley
PC.
Noling was reinstatement of her pretrial intervention agreement on July 31st, Your Honor.
But I think, I thought there was paperwork to be filed, that's why it was on the docket.
I do believe that paperwork was filed, Your Honor. We got the new pretrial intervention agreement signed, I believe. Okay.
Just let me check on that. Okay. It looks like the plea was on 7/31, and then on 8/13, it's listed as other. It's a two-page document, which is the pretrial intervention agreement. So we've
Okay.
got it.
Yes, Your Honor, we have it.
All right, I was nervous there. Thank you.
Listed
Appreciate
as
that.
other.
All right, thank you, Your Honor.
First one's not mine. McSweeney's not mine. That'd be Jay. Mr. Williams.
McSweeney.
Caitlin McSweeney.
Hey, Ms. McSweeney, how you doing? Judge, I don't have Ms. McSweeney on my docket. I'm sorry, she's on both? She's on both. All right. Okay, all right, that may explain it. Judge, what I do is I'll enter denial on the VOP. If an information has been filed on this afternoon's docket, okay. I'll enter a plea of not guilty on that, 15 days for prearrangement motions, trial by jury, and let's have the two cases tracked together. I'll come out to the jail and see her again once I get discovery or an offer that will cover everything.
I'm trying to track what's going on with both cases, and my system doesn't have everything in it, so I'm going back to look at it, the clerk system.
What I can do, Mr. Seek, is this, are both of these cases yours?
Yes, they are.
All right. Do you think you could give me an offer by this afternoon?
I think by this afternoon, yes.
Okay. Let's do this, Judge. Let's leave her on for her arraignment this afternoon, and I'll get with him. She's asking me if she can resolve it today.
When did she get put back on probation? Or it just started in April? November. So this is a second VOP. Oh, but it was a South End case, the violation of probation. You were in Fort Walton before, ma'am?
Walton and transferred over here immediately.
No, I mean, as far as
Oh, yeah.
your previous court
Yes.
case, your previous violation. I have no memory of it is what
Yes,
what I'm
it's my
trying
first
to
time
figure
being
out why I
here.
don't know anything about it, if it happened in April. So this is a second VOP, and it's based on a new law violation. All right. We'll see you back this afternoon at 1:30, ma'am.
All right.
He's still in Santa Rosa. Your Honor, if I could, before the court, it would be Sean Ruiz. He's supposed to be before the court today on 18 CF 1056, 18 CF 1381, 18 CF 1450. They transported him.
Do something. Mr. Nielsen, I'm getting feedback off of you, so thank you.
They transported him to Santa Rosa because he had a hearing in Santa Rosa, and it appears that they have not transported him back. I will have to check and see. Maybe they're just, that there's no transport back, and I'll need to do a motion in order. But this is not a situation where the client bonded out because he is on a no bond. It was Santa Rosa that did a motion in order to transport him over there. And I would just ask to set his case out for another month or so we can.
Yeah, let me see if I can figure out what they're doing with him over there, because
He had a misdemeanor charge over there, Your Honor, which was one of the basis for the violation of probation, and I believe that they were there to address that case.
court on Tuesday.
Oh, so he still has court.
Well, it's an arraignment date. I'm not sure if it's going to be waived or anything, but I'm showing it as an arraignment on September 2nd at 8 o'clock in front of Judge Gerard.
Hence, Your Honor, he's not here.
And he had another case.
He has a.
That was dismissed over there, another 25 mm case.
Okay.
But there was an order to transfer him for that, I believe, back in July.
But you're saying he's got yet another case.
Well, what does that say? So they transported him over there for what appears to be an arraignment, and they revoked his bond, and then it was null prost. But in the meantime, he has another in violation of injunction case that's set for Tuesday there. So what would you like to do with yours?
Your Honor, I would like to continue this out to the end of September, if not the beginning of October.
He also has an MM case over here with
That's
Judge
correct,
Ford on the
Judge Ford.
15th. Okay.
Yes, Your Honor.
That's what I had written in my notes. When you started talking about Santa Rosa County, I didn't know about that. All right, do you want to do the 25th, or you want later, September?
September 25th is fine, Your Honor.
September 25th, 9 o'clock,
We'll go
without
from there.
subpoenas. Okay. All right. For everyone that thought they might be on MIMS, he's in the south end. They've got it.
So he's going to be heard in front,
Oh.
Your Honor, this
Half of
is.
what we do is fixing problems.
This is David Smith. He's before the court on 21 CF 590. Your Honor, he asked me to obtain a court smart video. I did just get that video, so I do need to show him that. So we're going to request a continuance to 9/25 based on whatever the video shows. It'll influence how he wants to proceed.
Is that with or without subpoenas?
Without subpoenas, Your Honor.
All right. September 25th, 9 o'clock, without subpoenas.
No Travis Stone? No Travis Stone?
Travis Stone.
Out? Okay. Your Honor, this is Joseph Eric Thompson. He's before the court on the request that we had filed. I did it as a request instead of a motion, but either way, it amounts to the same thing. We are asking for additional access to additional discovery from the state. This particular case surrounds iCloud material, And we had retained an expert, and they're indicating that they don't have enough access to be able to obtain the information needed to try to help us with his case.
Whose iCloud is it?
It's allegedly my client's iCloud.
Ms. Basso?
Your Honor, I've provided the defense's request for additional discovery to the case officer, and he reviewed that. He indicated that their experts would be welcome to come make an appointment at the lab and come and review what they have. In this case, since it does contain suspected or charged child pornography images, it cannot be released.
Right.
But that certainly would be made available for the defense's review or any experts that need to see that. So we're ready to assist, but we can't, that's about all we can do at this point.
And so specifically, the iCloud information is available that is requested in here?
This defense request for additional discovery that you
Right,
filed?
number
Yes.
5.
This is what I forwarded to the investigator, and he indicated that would be the way we'd have to go about doing that.
Okay.
And if we run into any problems, then certainly your expert can let us know. We'll work with you.
Thank you.
Do you want an order stating anything, Ms. Rivers?
If the state's assuring that they will provide that access, I don't see any reason for that.
And she also requested a copy of the search warrants. I believe the investigator has dropped those onto a disk, and I'll be getting those to you as well. So there's no concern about turning those over.
Thank you.
All right.
Judge?
Thank you. What's his next court date? Does he have another court date already?
Yes, Your Honor, his next court date would be October 29th, I think.
October 29th, 9 o'clock. I don't see that it was actually set to that date yet. So
Well, Your Honor, we would ask for that date.
that's what I just want to make sure it was there. All right.
Your Honor, this is Vernon Webb. He's before the court on 22 CF 2054, 22 CF 2749. We would like to set this for contested hearing.
What date would you like to do that? The 25th?
Do you have room on the 25th?
Well, I'm not sure who it is.
That happen if that's what we need to do. I believe that is a court date. We have several things that day already.
All right, September 25th at 2 o'clock with subpoenas for an evidentiary.
Thank you, Your Honor.
All right, thank you, Mr. Webb. We'll see you back on that date.
September 25th. Yes. Your Honor, if I could address one or two other things that was on the docket. Bradley Pittman was listed as
I
status.
think I've already signed that order a while back.
You have, Your Honor. And also, Your Honor, I have filed a motion, I'm sorry, let me correct that. I filed a notice of hearing on Tony Tatum, 20 CF 1826, 20 CF 2406. Appellate Attorney Joe Arnold filed a motion requesting that motion to correct sentencing errors.
I'm trying to pull it up.
Yes. Yes, Your Honor. I'm sorry? The case numbers are 20 CF 1826, 20 CF 2406.
It wasn't on my docket, so I'm trying to figure out what it is. I mean,
Um,
I can see what it is now. It's a 3,800 motion, but normally these go to the staff attorney to take a look at first, and I just don't know if that's ever been done. Usually when it comes in, it gets automatically routed to them so they can take a look at it, but I haven't seen it yet.
I did provide a copy to your assistant because she asked for it.
I understand that, but what I'm saying is there's usually
I
a
know.
different protocol for doing these and not just
Yes, Your
setting
Honor.
them for hearings.
Your Honor, one of the thing I did want to clarify, in case we don't go forward today, the motion to correct sentencing errors, Mr. Arnold is asking for a complete resentencing. I wanted to get the court's take on whether it would have to be a complete resentencing with Mr. Tatum present, whether we need to bring him, or whether it would just be an amended judgment and sentence.
What I understand is I'm looking at the jail credit memorandum from February of 25, it says 732 days.
And they are indicating that it should be 748 days.
Well,
The motion also indicates that there was errors in the score sheet and that instead of it being 53.775 months, it should have been 50.775 months. And then subsection 3.
instead of
I'm sorry,
0.775, it should be 0.75?
53,
I understand, but 53 point,
yes, versus 50.
Oh, 50, okay.
3 months difference, Your Honor. And Your Honor, also in category, in subsection 3, he talks about the score sheet indicating violent felony offender of special concern, whereas the box should have been a different box unless the court did a written finding.
all right, well, I'm going to have to either bring it back this afternoon and let me read it if we have the time, or otherwise bring up another date. I mean, it was filed July 23rd, and it has to be done within 60 days, so, but this is, not a case I did any of these things on, so I have to familiarize myself with it.
Yes.
Probably go back and watch what happened, because I don't know, what he was sentenced to. Did the score even really matter in that situation? Was he given what he scored versus something else? And was that an agreement, even if the score sheet was wrong? I just have to figure all those things out.
Right. It was a contested hearing, Your Honor.
Okay, well, let me try to bring it back this afternoon if we have an actual break today. I'll take a look at it. Otherwise, this afternoon, if I don't have time to do that, I'll set it for another date. But
And if the court, when trying to decide, if the court would let me know if they want me to do a motion in order to transport Mr. Tatum.
I'll have to take a look at go
Yes,
through
sir.
all this. I mean, because they're
Multiple
talking about
issues.
Erlinger stuff, which is, as you probably know, is a federal case that came out relatively recently. A friend of mine actually wrote a very detailed article about it for the Defender magazine recently. But I just haven't had a chance to read into this, but it's just the, jury findings and things on it's and was an extension of Apprendi. So I have to go through and read all this, and I'll try to do that during our lunch break if we've got a lunch break.
Yes, sir.
And we'll readdress it this afternoon, because it's not even on my docket, or else I would have read all this yesterday. Thank you, Ms. Rivers. Travis Stone.
Your Honor, this is Travis Stone before the court on 24 CF 2274. We're going to enter a denial at this time. I'm going to request the 9/25 court date so I can have an opportunity to meet with Mr. Stone and go over everything.
Your Honor, the court did yesterday at 1:14 sign an order revoking his bond. It's my understanding there are some additional violations coming. So we ask the court to take him into custody at this time.
All right, I signed the order yesterday, so.
Come on, I was going to ask you for your phone number.
It just came through.
All right, does that change what you want to do as far as dates?
No, Your Honor, because I haven't had an opportunity to meet with them.
Okay.
You said 9:25?
Yes, please.
September 25th, 9 o'clock.
Yeah,
Mr.
to
Stone
see
will be
you.
taken into custody at this time.
I don't know.
I signed the order to take him into custody yesterday afternoon.
We'll find out more, okay?
This fountain actually is Mr. Maddox's case.
I thought she was on this afternoon, Your Honor.
Well, she's also on this morning.
All right, Your Honor, this is Miss Michelle Fountain before the court in 25 CF 1465, 25 CF 876, and 25 CF 549, Your Honor. Does the state have an offer at this time?
That was the offer I relayed to you.
Keaton?
Keaton, yeah.
Okay. So, yeah, I mean, even if.
Information for her for the new one. Was she given information for this afternoon?
So at this time, Your Honor, what we'll do is enter a not guilty plea for the new law offenses, Your Honor. Ask for trial by jury in 15 days for any pre-hearing motions and enter denials on the VOPs.
All right, Ms. Fountain, we're going to put you on October 29th at 9 o'clock for your pretrial conference on the new case. Accept your plea of not guilty, and we'll put the VOPs with that for purposes of status.
Thank you, Your Honor.
Thank you.
I'll see what I can do, Ms. Fountain.
Judge, this is Mrs. McSweeney. I think we've got a negotiated. I'm
Mrs.
sorry,
Lively.
Ms. Lively. I think we've worked out a negotiated plea on her. I'm just looking for my paperwork on it. I expected her to be called up later. I tell you what, if we can, yeah, no, give me a second, Judge. That's my problem. I'm looking in file. It's not hers. Judge, she's got a pending case with me. Here we go. She's also out of the order that I had everything in. I had her in alphabetical. So, Judge, she's got an original case with me, a new law violation that is 4625 CF 1351, plus she's got this VOP. The state has offered to resolve both cases with adjudication of guilt, 2 years community control. I've drafted up a plea offer on it. I've gone over her rights with her back in lockup. Ma'am, if this is what you want to do, I need to get your signature right there. And you mind if I date this for you?
No, sir.
And Your Honor, it is a downward departure based on an uncoerced plea.
Any issues with the 2 years of CC on the 2019 case as far as how much time she's got left for purposes of supervision?
Actually on administrative, thought that they had said they were just gonna finish that out and do the 2 years.
Obviously, we have no objection to that.
I mean, is that
Judge.
easier for you? Do it that way.
Easier for us unless they're gonna revoke her and give her old one, but she only has till 4 administrative, so.
If
So
that's
they're saying that there's only
Yes.
8 months left of potential supervision on the old case.
And the state is fine with that.
We agree to that as well, Judge.
Sorry, that was my misunderstanding.
So what are we going to call the old case, 990?
Just reinstate, is that what?
Reinstate to administrative probation for whatever purpose? Does that give?
I mean, is there any issue if she's already under community control? Yeah, just. Yeah. Yeah.
Well, my concern is she going to have two different probation officers?
Yeah,
And if she has a probation officer and a CC officer?
No, Your Honor, she would just finish out until 4/8/26 on that one would term, and then the 2 years would start.
Okay.
I just, sometimes y'all have different officers for different types, levels of probation, so I just want to make sure that wasn't going to be an issue after. Okay.
Yeah.
Okay.
Yeah.
Lives where? What?
In the
Live
state.
country.
In this state.
Yes, in this state,
Yes.
yes.
So we're just going to call that reinstate on 990.
Yes, Your Honor.
No objection from the defense, Judge.
And the 1351, it's going to be adjudication and guilt, 2 years, community control. It says concurrent, but it'll be concurrent to the reinstated probation of 990, substance abuse evaluation and treatment, random UAs.
Yes.
And court costs on 1351, 515.
That should be, usually I think what they do is the 515 plus $100 FDLE trust fund, which gives us 615.
615.
Sorry, Judge, I thought I'd remembered to put that in there.
All right, Ms. Lively, can you raise your right hand?
Yes, sir.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Yes, sir. Vicky Grimes Lively Lee, 9/7/61. September 7th, 1961.
All right, and Ms. Lively, you're here on a violation of probation in 2019 CF 990, as well as a new charge in 2025 CF 1351. It's actually 2 counts of possession of a controlled substance, which are third-degree felonies, punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you admit to your violation of probation and being reinstated to that probation with some costs. And the new case would be an adjudication of guilt, which is 2 felony convictions, 2 years of community control to be concurrent with your probation on the 19 case, substance abuse evaluation, any recommended treatment, random UAs, and some more costs. Is that what you want to do today?
Yes, sir.
You said this is a downward departure as well?
Yes, Your Honor.
Yes, sir.
All right, Ms. Lively, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you
I have.
understand it?
Yes, sir.
Did you sign it?
Yes, sir. It's signed.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are
I
you
am.
currently suffering from any mental health issues?
Not yet. I stay in the hospital, stay in that jailhouse, I would be, but right now I'm okay. No, I'm good.
Is this a joke to you, ma'am?
No, sir, this is not a
Okay.
joke.
Because I'm trying to make sure that you
No,
know what
sir.
you're doing here today. So when you say I don't have it yet, I have to ask you more questions.
No, sir, I'm good.
All right. Have you ever been diagnosed with a mental health illness?
No, sir.
All right. Are you sure? Okay. Let's keep the jokes to ourselves. I know sometimes it can get a little bit casual, but this is not the time. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for the plea?
No, sir.
Do you understand that if you admit your violation of probation in 2019 CF 990, that there won't be a hearing where the state would have to prove how you violated your probation?
Do you understand that you had the right to fight the violation of probation and make them prove it? Remember we talked about it?
Yes, sir, I understand that, but I'm good with what we're doing.
So you understand you're giving up that right?
Yes, sir.
And if you enter a no contest plea in 2025 CF 1351, do you understand that you're giving up your right to a trial?
Yes, sir.
And you understand you're giving up right to you're giving up your trial rights, which are on page 2 of the agreement that you signed.
Yes, sir.
Did you go over this agreement, ma'am?
Yes, sir.
Did you read the trial rights that you're waiving by signing this agreement?
Judge, I couldn't hand her.
I would like an answer from her, Mr. Williams.
Yes, sir, I understand what I'm doing.
Okay, so what are the trial rights that you're giving up?
That I'm giving up my right to a jury trial. I'm giving up anything after, subsequent to this, any kind of.
I'm going to go through them to make sure that you understand, Ms. Lively.
Yes, sir. I
Do
do.
you understand you're giving up the right to plead not guilty?
Yes, sir.
Do you understand that you're giving up the right to trial by judge or jury?
Yes, sir.
Do you understand that you're giving up the right to be represented or helped at trial by a lawyer?
Yes, sir.
Do you understand that you're giving up the right to compel or make any witnesses come to your trial?
Yes, sir.
Do you understand you're giving up your right to be present when witnesses testify against you?
Yes, sir.
Do you understand you're giving up the right to cross-examine witnesses who testify against you?
Yes, sir.
Do you understand you're giving up the right to remain silent and not testify against yourself?
Yes, sir.
Do you understand you're giving up the right to present any and all defenses that you may have?
Yes, sir.
Do you understand that you're giving up the right to appeal all matters, including the issue of guilt or innocence?
Yes, sir.
Do you understand you're giving up the right to file motions to suppress evidence?
Yes, sir.
Do you understand you're giving up the right to testify on your own behalf?
Yes, sir.
And do you understand that you're giving up the right for your attorney to further investigate these cases, including locating and deposing any potential witnesses?
Yes, sir.
Okay, so do you now understand the trial rights that you're
Yes,
giving
sir.
up? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
Are you admitting that you violated?
I'm
your
admitting I violated my probation, yes, sir.
And what is your plea to the new charge in 1351, 2 counts of possession of a controlled substance?
Guilty.
No contest.
No contest.
Don't plead guilty.
No contest.
I'll accept your no contest plea to the possession of controlled substance counts. That's 2 counts. And your admission to the VOP in 19 CF 990, your violation of probation with the underlying elderly neglect charge. In that 990 case, I'm going to reinstate you to your previous probation, $100 PD fee, and $100 cost of prosecution. In the 1351 case, I'm going to adjudicate you guilty, place you on 2 years of community control. That'll run concurrent with your probation. In the 990 case, you're going to do a substance abuse evaluation, any recommended treatment. You can do random urinalysis. Court costs will be $615 in that case, plus a $100 PD fee and the $50 application fee. This is a downward departure that the state has offered to you as an uncoerced plea bargain. Otherwise, Ms. Lively, you would have been doing 29.1 months in state prison. So I'd like to impress upon you the need to take this seriously, read the forms that you're given, listen to your probation officer and your community control officer and as they instruct you on these things, because if you come back on another violation, there's a good chance you're going to go to prison. Do you understand that?
Yes, sir, I do.
Okay.
Judge, can I put a couple of things on the record?
If you feel the need to.
Yes, sir. With regard to reading the document, there's no pass-through, so I read it to her rights line by line. Ms. Lively, did I also explain to you that the state has not yet provided discovery?
Yes, sir.
So I can't go over the discovery with you.
Yes, sir.
Did I also explain to you that sometimes these things come back, no drugs identified, and we don't have a lab report back as well?
Yes, sir, you explain that.
Are you doing this because you feel like it's in your best interest, though?
Yes, I am.
All right. That's all I wanted to get on the record, Judge.
All right, anything else?
No, Your Honor.
All right. Ms. Lively, you have to meet with probation, you're going to have to be fingerprinted, and then you have 30 days to appeal. Yes, ma'am? Cost of supervision will be waived due to the fact that she's indigent.
Thank you, Judge.
I'd like not to see you back in my courtroom,
I'd
Ms.
like not to
Lively.
be here. Thank you, Judge.
Your Honor, I had further discussions with the prosecutor in the case this morning. I gave her some
All right, who's this?
mitigation. Oh, I'm sorry. This is Michael Alfred Johnson. Case number is 2019 CF 2000. I had further discussions with the prosecutor this morning, gave her some mitigation evidence. They've agreed that Mr. Johnson's situation is best served by him going into a program. So I'm going to ask to continue his case so that my investigator can get him into one. We're looking at REAP, and then the mitigation evaluation by Dr. McDonald suggested 12 Oaks as well. So we'll see which one of those we can get him into. I'd move to continuing without subpoena since this is going to be resolved with the plea.
You on a suspended sentence?
Judge, he may well be. I know when I looked at it, he was, the last time he was sentenced, the suspended sentence was not reimposed. So it may be that there's no longer a suspended sentence on it. Basically, Judge, there are circumstances that are currently unknown to the court.
Well, I understand. I'm just wanting to make sure that we're addressing these things. I've seen it in the past and looking at cases where people have suspended sentences and they violate. He's accused of violating with a new law violation of a DUI. And so I want to make sure that we're addressing suspended sentences when they're already on the books.
Yes, sir.
All right. September 25th, 9 o'clock, no subpoenas.
All right. Judge, Ms. Kegaris is before the court for essentially an arraignment on her VOP. We're going to enter a denial at this time. We'll continue to talk with the state and try to get the case resolved.
So you're not setting it for an evidentiary?
Not at this time, Judge.
All right, September 25th, 9 o'clock, no subpoenas.
Thank you, Judge. All right, ma'am. I'll continue to talk with the state, and I'll come out and see you again once I get an answer from them, and we at least get a proposed resolution.
Yes, sir. September 25th.
Yes, ma'am.
Thank you.
Yes, ma'am. You go ahead. You go. Dalen Kendall. LeBeau, okay. Judge, I'm sorry I didn't have time to go back to talk to Mr. LeBeau, but it looks like we've got this worked out. What we're looking at is a reinstatement and keeping his withheld adjudication.
So what
I
would you
think
like to
the
do?
idea is that he's going to do 6 months community control and then whatever remained on his probation on probation.
So what would you like to do with it today, Mr. Williams?
Judge, passing. I'll go out and see him in a minute.
All right,
Maybe
pass them to the afternoon. I'd like to get through the morning docket, please.
Okay. Judge, this is Dalen Kendall. We've got a negotiated agreement in this case. Sir, if you sign it right there.
Right.
Yes, sir. Mind if I date it for you, sir?
Here you go.
This is 2 years of community control when he scores 53 months.
Yes, sir, Judge, there was some mitigation here as well. This is the one that was, this is probation's recommendation, first of all. And this is the one that was passed for the state to be able to talk with the victim last time we were in court. And this is consistent with the recommendation.
Mr. Kendall, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Jalen DeMar Kendall, 06/20/2003.
Mr. Kendall, you're here on a violation of probation in 2023 CF 2607, where the underlying charges were 2 counts of aggravated battery, which are second-degree felonies and punished by up to 15 years in state prison. Do you understand that?
Yes, sir.
I've been given a violation of probation community control plea agreement between you and the state that calls for you to admit to your violation of probation, revoke and term that probation, then put you on a new 2 years community control, followed by 3 years of regular probation. You're to complete the same terms and conditions of your previous probation that you violated, and then add that you're going to attend and successfully complete the Department of Corrections Fatherhood Program, $150 PD fee and $100 cost of prosecution. Is that what you want to do today?
Sir.
Did you go over this form with your lawyer?
Sir.
Did you sign it?
Yes, sir.
Did you understand it?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering an admission to your violation, there won't be a hearing where the state would have to prove that you violated? And you would understand that you're giving up all potential defenses that you may have to that violation. And you understand that by entering this plea, if you're not a U.S. citizen, you could be deported.
Yes, sir.
All right, and what is your plea to the violation of probation?
Admit. You can admit or deny. If you deny, then we have a hearing, we fight it. If you want to take this, you admit.
Admit.
I'm going to accept your admission as freely, voluntarily, knowingly given, revoke and terminate your previous probation. I'm going to put you on a new period of 2 years community control, followed by 3 years regular probation, same terms and conditions as your previous conditions or your previous probation. Add that you can successfully complete the Department of Corrections Fatherhood Program, $150 PD fee, $100 cost of prosecution, and the reason for the downward departure.
It's an uncoerced plea, Your Honor. Any submitted documentation for mitigation purposes.
I understand. All right, Mr. Kendall, you have to talk to probation behind you. I won't need your fingerprints because we already have those from the underlying case, but then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge.
And it's an adjudication of guilt.
Yes, I said that.
Yes, thank you.
So cost of supervision will be waived.
Okay. Ms. Livingston, this is the agreement we discussed back in lockup. Get your signature right there. $828.25. All right.
Thank you. Can you raise your right hand, ma'am? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Jessica Livingston, 3383.
And Ms. Livingston, you're here in 24 CF 2460 on a violation of probation. I've been handed a plea agreement between you and the state that calls for you to admit your violation. You'd be adjudicated guilty, sentenced to 9 months in county jail, credit for time served. Then you'd have a $150 PD fee and a $100 cost of prosecution. Is that what you want to do today?
Yes, sir.
Did you go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes.
This is also a downward departure, correct?
Yes, it is, Your Honor. I apologize.
I mean, by a tenth of a point, but.
Yes.
And the reason?
Uncoerced plea, Your Honor.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea, there won't be a violation of probation here where the state would have to prove that you violated?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Mm-hmm. Yes.
All right, and what is your plea to the violation of probation? Are you admitting or denying?
I'm
So would you like a hearing on your violation of probation, or are you admitting that you did it?
Yeah, no, I did violate, yes.
So you're admitting?
Yes. Sorry.
I'll accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to 9 months county jail, credit for time served, $150 PD fee, $100 cost of prosecution. Was she previously adjudicated?
Judge, I have that she was.
All right, ma'am. You have 30 days to appeal the judgment and sentence of the court. This was a downward departure as stated by the state attorney for purposes of an uncoerced plea bargain. Otherwise, it would have been 12.1 months prison.
Yes, sir.
It's only one case. It's 4 counts. All right. Mr. Williams, all you have is criminal mischief felony on here, but there was 3 counts of that criminal mischief plus possession
Oh, I'm
of
sorry, Judge.
paraphernalia.
I meant to put ×3 on that.
Okay, well. All right, that's concurrent for all counts.
Thank you, Judge.
And ma'am, you'll have 90 days after your release to pay your costs.
Okay.
Or set up a payment plan.
Yes, sir.
Probation. Revoke in term probation. Thank you. Can we just, on all further violation agreements, that we put revoke in term on the actual agreement?
Yes, sir.
Yes. Well, no, I'll give her the payment, 90 days to pay any monetary outstanding, otherwise it'll go to collections.
Yes, ma'am.
Just jail.
Sorry, Judge, in our office, we were thinking that Ms. McSweeney, or my secretary looked at the docket and thought that it was another attorney's. Judge, she's got a new law violation for arraignment this afternoon and then a violation. Is this the one?
Yeah, this is the one we were going to push to this afternoon.
The state's made an offer for 2 years community control on it.
Okay.
And I'll draft that up and come back and talk with you about it, okay?
All right, Ms. McSweeney, we'll see you in the afternoon.
Judge, for today's purposes, this is Danny Burton Mason. I'm going to be entering a denial for him. Looks like he's got a total of 3 cases on the violation.
All right, where would you like it placed, Mr. Williams?
Judge, I'm also,
What date would you like, Mr. Williams?
give me a date after the September date, Judge. I'm going to have somebody else interviewing.
All right, October 9th or October 30th?
Judge, I'm going to say October 9th.
All right, October 9th at, let's put it on 9 o'clock without subpoenas.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Judge, this is Mr. Moss. He's got the violation of probation. This is the case where we'd had him in court and for arraignment, and we're trying to plea the case out, and the court discovered that there was a VOP that had not yet come about. Let's put him on for this afternoon also. I'll talk with the state attorney again and see what the most recent offer is. And we'll try again to get it resolved. Yes. Mr. Lanehart, come on up. Judge, we provided a evaluation that substantiates or is basically the same as the previous evaluation when he violated before. I've spoken with the prosecutor about it. They're asking for agency for personal development, right?
Persons with disabilities?
Persons with disabilities.
Yes, sir. Based on the nature of the findings, we are asking that APD perform an evaluation of Mr. Lanehart. And once they would receive that, then we'll know where to proceed.
I don't think I have a basis to object to that, so I don't.
I just haven't seen a report. It looks like there was a reciprocal discovery that was dated August 6th, but I don't have the report.
To go get my file.
You have a copy, Jay?
Yep.
I can give the judge mine if you don't.
Oh, here it is. It came in that day. I apologize.
Emails typically a public record in Florida. We don't want to necessarily send them by email, although I guess sometimes we do.
Your office did that on August 6th. All right, are you going to send me an order on the APD? I think Mr. Maddox is working on getting those done and has become the APD professional now, right?
Trying, Your Honor.
Okay.
Would you mind doing that?
Submitting the order for that? Sure, what was the case?
Sir, it's going to be Mr. Winston Lanehart.
Yeah.
Thank you, Your Honor.
All right, thank you. Let's put him, what date do you want to put him on for? Maybe October?
That would probably be good.
All right, let's do Mr. Williams, October 30th.
All right, Judge.
It's been, at least, I think Mr. Maddox experienced that the APD evaluations can take a little bit of time, so.
They can, Your Honor. Again, there's just been an issue with them receiving the orders. I'll make sure to send this one directly to Mr. Sanchez.
All right, October 30th, 9 o'clock.
Thank you, Judge.
Sure.
Okay. So you're going to talk with another agency to do another evaluation on you, okay?
Change all arraignment dates to have. Okay, we just don't have the time to complete all this stuff in the time that's currently set, so I'm trying to add dates and times where we can get more motions done. Everything takes so long.
Judge, okay, Judge, let's pass this for the earlier, maybe the next September date. I think we can probably get this one worked out. I did
25th.
see her at the jail, and I need to check with my investigator on something and talk with the state.
You mean the September 25th date?
Yes, sir.
September 25th, 9 o'clock without subpoenas.
All right, ma'am.
Yes. Miscellaneous VOPs is just block every afternoon on those dates.
I've almost got it written up, but yes, I'll be ready as soon as I have the finishing touches on it here.
Is there anyone else? Your name, sir? Alexander? Okay. Are you representing Mr. Alexander? Supposed to be on the 25th. This is Bernard Alexander. He was on the docket for Monday at 1 o'clock. Didn't appear.
Yes, sir. As I'd explained on Monday, I've never had a problem with him showing up or anything like that. He contacted our office. I guess it was it Monday or?
Yesterday, I got a voicemail, and I spoke to somebody yesterday.
And so I told him to come in this morning.
Okay. What's the plan with the case?
What is the case number again, Your Honor? I'm sorry.
I've got it as 25 CF 294. It was set on Monday at 1 o'clock on the pretrial docket.
Judge, I don't know if we went into it at all on Monday, but
I don't have any notes, so.
Okay, this is the gentleman where we have taken some depositions in this case. We're trying to track down the other individual that had been in the car. He had given that individual's name. It's mentioned in the arrest reports. We have located a fairly extensive drug history on the guy, and so I'm going to ask for one more continuance to try to get that straightened out.
Mr. Dawson?
Yes, it is, Judge. I think his first name's Stephen.
All right, State, first of all, as far as the capias from Monday?
State has no objection to, we'll leave it to the court's discretion, Your Honor.
All right, as far as the continuance?
No objection to that either, Your Honor.
Have you had any contact with them at all?
Any contact with?
Mr. Dawson?
No, I have not, Judge. I did find some paperwork, and Mr. Alexander has spoken with my investigator. Actually wound up spending about an hour with him a week or two ago. I'm sorry.
All right. For Bernard Alexander, 25 CF 294, I'll withdraw the capias, grant the motion to continue. It's going to be October 27th at 1 o'clock. You're here, and I'm telling you now, Mr. Alexander.
I'm going to put it in my calendar.
You're fine to do that. I just don't reach into your pockets while you're up here. Security doesn't like that. It's okay, though. October 27th, 1 o'clock.
Thank you, Judge.
Withdraw the capias.
Get with Dave, let him know. Okay.
I got a message yesterday.
Order to appear. Thank you. All right, you Miss Pryor, come on up. 2014 CF 1917. Well, she's on the docket. There's an order telling her to appear, but she's not on the docket. Only signed 22 days ago.
Did you say 1917, Your Honor?
2014 CF 1917.
14. Explain.
Issue, there's $19,800 or so in arrears on restitution payments.
That has been paid. I have a copy of the check and a copy.
Have you provided that to probation?
Yes, and to the state where they have it. There it is. In the email, they said because of the amount,
it takes longer to process.
I give y'all 20 grand.
They don't try to give it to me.
Anyone else?
Probation where I have to pay my additional fees. That's what I was
What's to catch you up?
behind.
Okay.
And to get me to the current, what I,
Yeah, once it's posted, it hasn't posted in our computer yet because it
yeah,
went through
yeah.
yesterday, so.
He said it would take several days because they have to investigate it or whatever. I sent him a cashier's check on the 21st, August 21st. No. That, I just contacted them
And they didn't receive it.
Oh, I got you. I got you.
Yeah. I'm saying they started on the 26th, so it's 2 days ago, so it hasn't made it to our.
Yeah.
Yeah, because she had to give a certain amount monthly.
Correct.
She wasn't making her monthly payment.
Yes, once this post, I should actually be a little bit ahead. Yeah, no, I still. I already emailed it to her.
Okay.
All right, what have y'all been able to figure out?
So basically, she has confirmation that she sent in her money order. Because the money order was so large, it takes a little while to process, so it hasn't made it over to our computer yet. But the email that she has came from Crunchbase, so I can't 100% verify that it went through until it comes over to our system, but it does take a little while when it's that much.
So would probation be asking to dismiss the violation? All right. Violation's dismissed. You're still on probation, obviously. You
Right.
know that for another 5 years or so.
Right.
Just keep making your payments. It just gets to a situation if they're not being paid.
And I'll be back up here.
We don't wait till the last month and say, now you're in a
Right.
situation.
Exactly.
BOP is dismissed.
Do you need me for anything else?
Yes. Sorry, therefore, Ms. Baggett. Date right here. Yes, ma'am. 8/28/25. All right, Your Honor, we've reached a resolution in this matter. If I may approach, this is Ms. Tara Baggett, recalled in 25 CF 910.
We know how much probation is left.
In this, Your Honor, her scheduled termination date is 6/18/2027. The original term of probation was 2 years, so the remainder of it's being modified to community control.
So it's going to be approximately 22 months or so of community control?
Maybe a little bit more, Your Honor, but yes.
Did you say June of 28?
6/18/2027.
27.
Yes, Your Honor, so about 22 months.
Okay.
Sorry.
All right, Ms. Baggett, can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your name and date of birth, please?
Tara Baggett, 3486.
And Ms. Baggett, you're here in 25 CF 910 with a violation of probation, a third-degree felony. Do you understand that?
Yes.
So she's only been on probation since June.
Yes, Your Honor.
And it's the violations for absconding.
There was a residency issue, yes, Your Honor. I've confirmed with her that she does have a place to go.
All right, do you understand community control means you have to stay in your residence unless it's for an approved activity that you put on a schedule ahead of time, right?
Yes, sir.
Okay.
Can I call in if that
You're
arises?
gonna have to talk, you're gonna have to talk to probation about that.
So you understand, it's weekly reporting every week
I know.
in the office.
Yes, sir.
And you stay at the house.
Yes.
Unless you're going to work.
Yeah, that's what I was saying. Like, if I get a job interview, do I just call it in or do I report, do I?
You have to report every week in
Okay.
person.
Okay,
Yeah, you'll
okay.
be accountable for every hour of the day on a piece of paper.
Okay.
And if you're outside of that piece of paper,
And I've seen violations as short as people being less than 10 minutes away from their, like, being away from their house are less than 10 minutes.
Yeah,
So
that's fine.
you have to take it seriously.
Yes, I do.
Yes, Your Honor.
All right, Ms. Baggett, did you go through this plea agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
All right, are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way?
No, sir.
Anyone promise you anything in order to entice you to plea?
No, sir.
You understand that there won't be a VOP hearing because of your being admitted your probation violation today?
Yes, sir.
You understand you're waiving any potential defenses that you may have to that violation?
Yes, sir.
And do you understand that if you're not a U.S. citizen, that you could be deported because of this?
Yes, sir.
All right. What is your plea to the violation of probation? Are you admitting or denying it?
Admitting.
Accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty. Was she adjudicated guilty before?
It was, Your Honor.
Okay. $100 VOP fee, $150 cost of defense. Modify your probation to be community control for the remainder of your supervision, which we talked about is about 22 months.
Yes, sir.
Complete all original terms and waive cost of supervision due to the fact that you are indigent. Make sure you talk to probation before you leave the room this now afternoon. We do need fingerprints? You didn't have fingerprints from before? Cool. And you have 30 days to appeal the judgment and sentence. All right, go talk to probation, then they'll fingerprint you.
Good luck, ma'am.
If y'all are here for the 12:30 docket, we're going to be taking a break and closing down the courtroom before then. Thank you.
Okay.
What are we doing with Mr. Kami?
She didn't tell me about this. Can we put it on this afternoon? I'm sorry.
So, Your Honor, I had reached an agreement with Ms. Leone in this case. She's had to leave, Your Honor. She said that Mr. Sheik would probably be able to sign it for her. I think that the terms haven't been fully relayed to Mr. Sheik, so Mr. Sheik isn't comfortable signing it. Could we just put him on this afternoon, Your Honor? We have reached a resolution. I've got it written up.
All right, Mr. Kami, we'll see you back this afternoon.
We'll get it done this
Hopefully
afternoon.
they'll figure it all out for us. All right, anybody else left for the morning?
Judge, probation brought up again Amy Harrell. She entered a plea on 8/7, was sentenced to, say, 6 months county jail. We did not specify in the sentence
Revoke and term the probation on Ms. Harrell.
Thank you, Your Honor.
Anything else?
Yes, sir, I just have the score sheet on Mr. Wilson that I owed you.
I know, it's just, yes. I'm sorry, I was just hoping for more than 20 minutes of a break, which we're going to take.